Welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be taking it to 3 o'clock, and you know if it's the Law and Crime Network, you know there are multiple live trials of huge significance and very, very interesting, all being handled at one time. So let's break it down real quick at what we're looking at. All right, let me bring on Gene Rossi, one of my besties here, legal analyst at the Law and Crime Network, over 30 years with the DOJ. He's tried copious amounts of cases, trained many prosecutors. Speaking of the training, Gene Rossi, again, I don't know what's allowed in certain states versus other states. And while she's very passionate, and I like this prosecutor, I think she's very good, but that comment about that they have 3 lawyers because they have to combat all these lies and all these deceptions, again, why go there? Why get close? People are entitled to representation. In Jersey, that's a reversal. Gene?
Oh, Bob, in federal court in Alexandria, Virginia, that not only would be a reversal, that could cause an attorney to lose his job. Now, I do want to say this in defense of Ms. Young, the prosecutor. There's a concept called invited error. And if the defense attorney in his or her closing made a ad hominem attack against the prosecutors, including Ms. Young, saying they're politically motivated, this, that, and the other thing, that invited error allows Ms. Young to get up and defend her honor, if you will, and also the honor of her 2 colleagues. I don't know if that happened, but even if you had invited error where you could get up, in my courtrooms in federal court in Alexandria, Virginia, the judge would stop me, he would admonish me, or she would, and I will be totally embarrassed, plus it would be a reversible error.
Yeah, well, I'm queasy with invited error. I'm queasy with it because it's like lipstick on a pig. It still doesn't look good at the end of the day. And to your point, I think is what you're saying is that the appropriate thing to do, at least in my mind, just to keep it clean, keep that record clean, Gene Rossi, no reversals of prosecutions, no reversals. You go to the judge and you say, Judge, that was an inappropriate comment. I want an instruction given to the jury. And like you said, when the judge gives that instruction, it's even worse. I don't want to cure it myself and have someone down the road with a pocket protector and a pencil tell me that I went over the line.
Absolutely. And it's funny, when I trained my baby prosecutors, I said exactly what the great Bianchi just said. Have a sidebar, say, Your Honor, I believe invited error applies here. I would like to say the following, but I would tone it down a lot.
Right. All right. Well, Gene, listen, we in total respect this prosecutor. I love her style. She's very fiery. But the one thing that I was always concerned about with fiery prosecutors is that they don't tip that balance too far. I don't know if she has. That's up to the state courts to make that decision should there be a conviction. But she certainly is entertaining and certainly riveting as a trial lawyer. And I'm sure the jury is riveted, too. Let's listen to some more. Yikes. Hey, Gene, I love her passion and her fire. But my goodness. First of all, a juror could sit there and think maybe she's just completely biased and not really taking everything because she's so emotional. She goes right to that line. But again, some of these comments that I have been there for 20 years as a prosecutor, and I have never seen evil like this. And the comment that I beg you, let's keep it clear so the audience understands we're not being persnickety here. Summations and openings are meant to talk about evidence. Evidence adduced during the course of this trial, not her 20 years as a prosecutor and her vouching for her case, and that's the term that they use, vouching, quote unquote, by saying that this is the worst case she's ever had. Gene, again, Georgia may be letting this happen, but I can't imagine this isn't commentary on the evidence.
Well, guess what? You know who was asleep at the switch?
Judge.
The defense attorney and the judge. Putting aside the judge, the defense attorney should have been injecting. I'm sorry. You got to preserve that error. And I got to tell you this is a case that may go to the Supreme Court. Some of those words, I'm embarrassed. I'm embarrassed. And here's the thing that really troubles me. Unless the evidence supported it, and Bob, you're right. If the evidence supports it, you can say it. You can draw inferences. But this whole discussion about the Ku Klux Klan, I hope there was something in the record to suggest that she was affiliated with the Ku Klux Klan. She basically said she was a member of the Klan.
Yeah, I mean, I don't know. I can't attest to that factual issue. But I can say this. I can say that when you sit there and tell a jury something like, in all that I've seen evil, I see evil every day. By the way, that's a problem. Talking about evil. This isn't about evil. It's about whether you violated the statutes in that state, the laws of that state. And then to say, and in my 20 years, this is the worst, most evil two people, you are so far outside the bounds of the evidence introduced during the case. Don't fall down the rabbit hole, prosecutor. You got a strong case.
Bob, here's the thing, and what I taught people is, you can say what they did was evil, okay? What they did was evil. They took Laila's life, all right, for no reason, period. But you can't cross that Rubicon, and what you just said is that they are evil, period. That's a brush of character, and that's where you get into trouble. And I will say this: in studying prosecutorial misconduct at the federal level, not the state level, but I've read a few state court cases. Oftentimes, prosecutorial misconduct occurs in rebuttal, and as you know, Bob, when you're doing that rebuttal, your armpits are soaking wet. Your adrenaline's going. You want to just clobber that ball and hit it out of the park, and that's where you make mistakes.
Gene, I want to go to that rabbit hole. You are 100% correct. And at least in my state, and I think I've read a number of different decisions from a number of different states, it seems relatively consistent. If there is a way a case is going to get reversed, or gets reversed quite often, is through inappropriate comments made by the prosecutor in closing statements. And you've got to be careful and mature not to fall into that rabbit hole and respond to something that the defense said, because they don't have the same obligation that you have. As a prosecutor, you have specific responsibilities that are greater than that of which a defense attorney has. So if you're responding to it and you're really worked up and torqued up, now I don't know if that's her demeanor. I don't know if that's her show, that's her game face. I'm not really sure, but you're right, Gene. That's what causes people to go over the line. And in a case like this, it comes back and it doesn't do anybody any good.
No, I think she's an extremely talented prosecutor. She has passion. She has energy. And I'm sure her closing, the initial closing, was perfection. But in this rebuttal, I got it the sense, you do too, if this were federal court in Virginia, it would be a mistrial.
Right. Well, listen, I mean, I'm going to give the benefit of the doubt that maybe the laws there are different, and they could be with regard to how sensitive the appellate courts are to statements made in summation. If she did not go over the line, she did a great rebuttal. If she did, not so much. We got to take a break. We'll be right back. So what we're looking at there is a defense closing statement. Gene, we've talked about the trickery that's going on here, if you will, and how this lawyer is going to thread and needle representing both of these clients who have or could potentially have antagonistic defenses. So what we saw on that clip, though, is exactly where I thought she was going to go last week when we talked about this, to say all these people have contact with this child and nobody recognizes it until after the charges are brought. And then she used the word, based out of hindsight and necessity, now they say it's abuse when they didn't say it before. And that the husband could avail himself of the fact that I didn't see this abuse either. So she's done so far the argument that would be Joseph's best argument, but curious where she's going to go with respect to the wife.
I was just going to say that, Bob. She is doing a phenomenal job representing Joseph. Then she has to put on another hat and represent Jennifer. And those arguments may be in conflict. That is called grounds for recusal. My goodness gracious.
Yeah, it's interesting. Like we said, just so our audience understands, it's atypical that a court will allow a singular defense attorney to represent co-defendants in the same case, because not only of the potential, an actual conflict, but the potential a conflict could occur during the course of the trial. And Gene, me and you have been around the block trying cases. There are times where you have a symbiotic defense going in, or as a prosecutor, you know that they're on the same page, and then during the course of the trial, things start to diverge a little bit, but you have two separate lawyers that are able to make the fulsome argument with respect to protecting each of their clients. She can't really do that here.
No, I'll give you a good example. I assume they're both incarcerated. She goes to the jail, meets with Jennifer, and then she goes in the same jail, another part of jail, and meets with Joseph. Joseph says, "You know what, Corinne? I want to plead guilty, and I want to testify against my wife because I don't want to go to jail." So Corinne's thinking, "Oh my God, if he cooperates, he's going to nail Jennifer to the wall." That's a total conflict.
Yeah, and interesting that you bring that out, Gene, because the lawyer was quick to say that they only charged Joseph because they wanted him to turn on Jennifer, and because he did not, because he didn't see anything or didn't know anything, that's why he's sitting in that chair. A good argument to make. But she had more to say in the defense closing. Let's go to one more clip, Gene. Okay, Gene, I mean, this forensic pathologist, irrespective of what the defense says, was a very good witness for the government. And it's still, though, does it answer the question ultimately of whether this was an accident, that is CPR and the Heimlich maneuver gone awry, or whether or not there was an actual assault on the child and that was just a cover story? And let's not forget that 911 tape.
Absolutely. I think this was one of the best witnesses the government had. And the reason I love her is it gets to my view of experts sometimes. They get a little haughty. They get a little too full of themselves. She was someone you'd have at your kitchen table just talking about the weather in a baseball or football game, and she explained things. That was the best part. She was an explainer in chief.
Yeah, Gene, we actually had said that we would consider where typically we would bury the medical examiner somewhere in the middle of a case, talking about primacy and recency, that we may have led off with her as a witness because she really does a good job, at least for the state. Now, I know the defense disagrees with this. She does a good job at laying out this is no accident. This is how the mechanism of this injury occurred, and all other states' evidence would fall in line with that. Do you agree with that assessment? Would you call her first, if you could?
You know, I don't know if I'd call her first. I'd call her towards the end. You know, the recency argument. I don't know if she'd be the leadoff hitter. That one is a tough one.
Yeah, yep. Okay, well, Gene, that was not to go unrebutted, though. In this very well-lawyered case in general, we can be armchair quarterbacks for sure, but in the totality of this case, both lawyers, the prosecution and defense, did a great job with what they had. The defense put on a forensic pathologist as well. Let's take a listen. All right, Gene, this is where the defense is going in the case, saying that, by the way, the state didn't do anything to rebut what he said. They did not take, any witness that would rebut what he said. But what was really compelling to me in his testimony is that, remember, the cops are in charge of an investigation, folks. And if they're going to be bringing charges like murder charges against somebody, you better do some good crime scene processing. And you don't release the scene until you have it buttoned down completely. What this pathologist is saying is that there's a picture, Gene, of the crime scene photos of potentially a piece of chicken in the sink. Did I hear that right?
Did he say it was a photo, or did he say when he got to the house there was still a piece of chicken in the sink?
I thought he saw it from a crime scene photo. This is the defense expert, so I don't think that he was retained at that point in time to be there. But
well, here's a problem I have with this testimony. He went to the scene of the crime after Laila passed away, allegedly murdered, and he listened to the defendant describe how she performed CPR. So his entire conclusion, Bob Bianchi, is based in toto, on the version of events given to him by the defendant.
Well, I may have heard this a little bit differently or see it a little bit differently. I think that he listened to the defendant's version of events like all of them did and had all of the other evidence in the case. But I thought what he was trying to drive home was that I cannot say that the version of events that was provided by the defendant is contrary to the evidence. In other words, it's consistent with the forensic evidence in the case. What I don't get is how he's getting around all those other injuries. That's going to be the difficulty in my mind with the jurors. But he's done a good enough job throwing some shade on this, Gene.
Oh, he is. But I would just make I'd have a field day in cross-examination in the fact that he relied on the demonstration done in front of him while she's been charged at her home. And I'd like to go back to the tape. If he said, I saw the chicken in a photo, fine. But if he got to the house and there was still chicken in the sink, wow, that raises a big red flag.
Yeah, I'm going to see if I can have our producers figure that out for us. Gene Rossi, always bringing the heat here. Always, Gene Rossi. Your legal analysis is always in toto. In toto. We got to go to break. We'll be right back. So, Gene, the prosecutor, let's talk about a different style, but he's very effective. And I think that he brought together the most important and salient things, which is what a prosecutor is supposed to do: deliver information that the jury will accept as being proof beyond a reasonable doubt. He ties in her injuries to say, it's not a mistake, it's not an accident, it's not CPR. Look at Millie. She's got injuries. Also, the aging and varying different injuries that she has, the victim in this case, and that the injuries are not normal, and all the experts testified that, including that powerful ER expert, doing a nice job saying to them in the end, the most important thing, which I said in every trial as a prosecutor: use your common sense.
Yeah, and she showed the photo, but I like this style. And for the chat room, this is the initial closing. The rebuttal is always high octane. So he's got a little governor on his engine right now. If he were doing rebuttal, it probably would be more high octane. But he's showing those photos, and he's taking his little PowerPoint red dot thing, and he's circling where the bruises are.
Right.
But what really impresses me, Bob, is that the bruises were deep into the muscle and behind.
Right, and places that they ordinarily wouldn't be. Listen, I'm sorry to cut you off, Gene. We got to go to a quick break. We'll be right back.